Good morning, everybody. I hope everyone had a wonderful weekend. Perhaps that's our last summer weather weekend that we'll be enjoying for the year. We'll see what happens. So this morning, we have 4 cases that are on our docket. And today is October 6th. Welcome to the First District Court of Appeals. I'm going to call out the 4 cases, the last of which is submitted on the briefs. And as I call the case, please identify yourself in the readiness to proceed. I'm going to pause with the second case because that case is pro se. So the first case is case number C250020, Nicole Littlejohn versus AFSCME.
Jay Carson, Your Honor, on behalf of Ms. Littlejohn, and ready to proceed.
Okay.
Kim Massey-Gilbert-Narden for AFSCME, ready to go.
Okay, thank you. And is all counsel here on both sides that were intended to be here this morning? Okay, thank you. Okay, the next case is, our cases number C250120, 121, 122, State of Ohio versus Kathleen Tribble. So this is pro se, and you are?
My name's Alexa Wingscott, and I'm here on behalf of the Village of Newtown, State of Ohio.
Okay, so very good. And,
I don't think Ms. Tribble is probably here.
okay, understood. All righty. The next case that we have is case number C250076, State of Ohio versus Darian Campbell.
Josh Thompson on behalf of Mr. Campbell, Your Honor, ready to proceed.
Good morning.
Your Honor, State of Ohio, Your Honor.
Okay. And the final case we have is submitted on the briefs, is case number C250081, State of Ohio versus Kent Smith. So we'll start with the first case, Littlejohn v. AFSCME. Counsel, when you're ready, you can come up to the podium. Good morning again. How are you?
Good morning.
Would you like to reserve time?
I would. 3 minutes, Your Honor.
All right, whenever you're ready.
May it please the court, for years, my client, Nicole Littlejohn, has sought to extricate herself from financially supporting a public sector union with which she disagrees and to recover the dues that have been taken from her paycheck after she had resigned from the union. She has since found herself in a procedural catch-22 and in trying to obtain that recovery. And today she asked this court, where can she go to have her dispute heard? Some background is...
So is your position that she has not had her dispute heard at all?
It is, Your Honor.
Okay. So there was nothing that took place before the EEOC then?
Before the State Employment Relations Board.
Okay. And there was
She
nothing there?
submitted a claim styled as a potential unfair labor practice. She did that because prior litigation in which claimants which had substantively identical situations to hers, the 10th District Court of Appeals said, no, CERB has exclusive jurisdiction. So Ms. Littlejohn, though believing her claims are contractual in nature, which I think the complaint and bears out that they are, filed them in CERB. CERB, as expected, said, these aren't unfair labor practice claims. Case dismissed. So there was never any adjudication of her contract claims, which she wanted.
Let's
Yet she
say,
had no choice
let's say
but to-
hypothetically she had filed first in common pleas. Is that an option she had?
I suppose it could have been an option, but after Littlejohn, the only controlling legal authority in the state was that she had to go to CERB.
Well,
And-
isn't there contrary law that says to the extent there's some independent basis? It seems like you're saying there's an independent basis, and there's contrary authority that basically says if you have an independent basis that is outside of the collective bargaining law of Ohio, you have a forum.
And that's exactly the case she made, and that's exactly the
But
facts
she,
that were before
but she
the-
elected to go to CERB first. And once she does that, doesn't the case law tell us she's elected the exclusive jurisdiction of SERB.
No, Your Honor, I would disagree with that. Because, first of all, I'd start to say that she ought not to be penalized for doing what the 10th District Court of Appeals essentially ordered on cases with identical facts. The pleadings in both cases were nearly identical, I know because I drafted them myself. It would have been a potential Rule 11 violation, I think, for her to try to go to a common pleas court first after a court had said the only controlling authority in the state had said you have to go to SERB. So she did that. That said, the question then is, did her complaint allege unfair labor practice? It didn't. And that's exactly what SERB said.
Let me
It
see if
said
I
these aren't
understand what
unfair
you're
labor
saying. Are you
practices.
saying that she followed a determination that pre-existed from the 10th, you said district?
Your Honor.
District Court of Appeals,
Yes.
right? And are you then asking us to make a determination that is different than that already made by the 10th?
Yes.
That's really
Yeah.
the heart of your argument?
Yes, we believe that the 10th District got it wrong. We tried the 10th District's approach and went to SERB first. And Your Honor, I think it's significant to note, in her charge with SERB, she noted, I'm doing this because the 10th District says I have to go to SERB first. And I'm reserving my rights to seek other claims, other satisfaction after this.
But, I mean, she had to be aware that there was this case law that says the test for exclusive jurisdiction is if you file with SERB, SERB has exclusive jurisdiction.
Your Honor.
That pre-existed even the Darling case, yes?
Your Honor, the distinction I would draw is I don't think the case law says if you file with SERB, SERB has exclusive jurisdiction. SERB has exclusive jurisdiction if you file with them and what you have alleged is an unfair labor practice. Obviously, SERB wouldn't have jurisdiction if, say, you're on in a car accident on your way to your work, which has a collective bargaining agreement. That, you could plead that before SERB, but SERB certainly wouldn't have jurisdiction, much less exclusive jurisdiction that would carry some sort of res judicata effect afterwards.
Then, as to your complaint, my understanding is you're framing this as a declaratory judgment.
That's correct, Your Honor.
So typically in a declaratory judgment case, there's some contractual provision, some writing, some thing that the parties disagree about in regards to its legal meaning that you want clarity from the court. So what is her contract? Is it just the checkoff agreement? Or?
That's it, Your Honor. That's the only written contract that Ms. Littlejohn had with the union. And her position is, this is a contract, and this is the position that the Ninth District took in the Belgao case, and other circuits have followed, that, listen, setting aside Janus, these agreements with a union member and its union regarding their membership is a purely private contract. So that's hence this action. So the dispute is, she believes that provisions of that contract violate Ohio law.
And the only contract really we have in front of us is the authorization membership checkoff agreement. There's nothing else to the...
That's correct, Your Honor.
Okay, so the courts, how do we, what meaning are we supposed to declare in regards to that? I mean, I know there's some broad relief
Right.
that you seek, but
Yeah.
there's this is a pretty unambiguous, brief sort of document that doesn't even seem to rise to the level of a contract. Maybe it is a contract?
Well, I guess that's exactly the question, Your Honor. Is that a contract? What we sought with the Court of Common Pleas was a declaration that writing, to the extent it's a contract, is invalid for a number of reasons. One, lack of mutual consideration. Two, it contains a unenforceable liquidated damages penalty. Three, lack of meeting of the minds. Four, unconscionability, all of which are regular contract theories that could be raised through a declaratory judgment to say, hey, this contract I've got isn't valid. And that's what she's looking for. And to be clear, she's not asking this court to make that decision. She's asking this court to make the decision of where she can litigate that claim, which she contends would be the common pleas, being that she tried SERB first. SERB says our jurisdiction is limited to unfair labor practices.
And she attaches to the complaint, or includes in the complaint, basically what she frames as an administrative appeal, or what you frame as an administrative appeal.
Your Honor, we added that as sort of a belt and suspenders type pleading. My sense, and I believe we've stated this in the briefs, I don't think that SERB's decision, the way it came down, is appealable, because it's a sort of decision on essentially its jurisdiction. It's not a decision on the merits. There's no facts that are found. It simply says, this is not an unfair labor practice. This isn't what we do.
Isn't there some other way to correct some mistake by SERB?
I wish there were, but I don't believe that there is.
Isn't there a mandamus action?
I don't believe so, Your Honor, because I don't think SERB would have a clear duty to hear a case, which, again, our contention is really shouldn't be in front of SERB. The only reason we did that was so to preclude the argument that we hadn't gone to SERB in the first place, that we hadn't exhausted remedies, and to some extent, honestly, Your Honor, to kind of prove the point, to say, listen, if the court's telling us we have to go to SERB, SERB is going to say there's no relief for you here. Please go somewhere else, which is what brings me here today.
In this case, do we have any authority over SERB?
I don't believe that you do, Your Honor. I think you could issue an order that might, in the future, right, be read as authority on SERB. And to be clear, the court didn't ask this, but I'll volunteer it. In later cases with these same facts, we've sought to join SERB as a party so that we could get clarity on these issues. SERB has asserted and been dismissed, saying we're not a party. This isn't our business. So in this case, I don't know that the court has authority to order SERB to hear a case. That said, I have to say I haven't looked at that issue enough to say whether it would. Obviously, there'd be conflicting decisions between the 10th Circuit or 10th District's decision saying SERB has exclusive jurisdiction, and an opinion from this court saying that SERB must hear the case after SERB's declined to hear it.
But that would only be if we somehow reach that this is somehow a judiciable order that can be appealed.
Correct.
Which there's case law that says the determination is not justiciable.
Correct.
Yeah,
And hence
why I asked the question I
Yeah,
asked.
and hence Ms. Littlejohn's predicament. On the one hand, beginning with Janus and Belgao, court said, no, these are state contract issues. Please take them up with your state courts. The Darling plaintiffs, again, pled exactly the same facts. And the trial court and court of appeals said, no, this has to go to SERB.
So assuming that you properly argue that it's not a contract to begin with, how would you foresee that playing out in this court?
I think if this court grants the relief that Ms. Littlejohn is looking for, it remands it to the common pleas court, and at that point, there's a trial held. Now, maybe this could be done on summary judgment or not, but there is a litigation and adjudication on is this a valid contract or not.
So that the court basically just said, I don't have jurisdiction. None of the merits issues were reached. You'd have to go back and start at square one in regards to, is this a contract? Is there consideration?
Correct.
And the relief that you seek is really just the return of the dues that she, after she submitted her termination?
That's correct, Your Honor. And again, it's a strange path she's had to walk to get there.
So like below, she'd have to even litigate that she failed to opt out in the opt-out period.
I think those would be factual issues that would be for the trial court to determine. Her position in her complaint that she filed was she opted out, and to the extent that the opt-out provision, well, I guess her position is more that the opt-out provision is invalid, in that the contract ought to let her walk away at any time. If you walk away from a contract, if you repudiate a contract, the opposing party has a right to say, all right, you breached the contract, but here's what you owe me. And one of her claims is you can't be owed the entire rest of the balance of the contract unless there's some reason that that's tied to litigated damage. It's sort of the gym membership you can't quit. And I submit that this sort of action in a consumer setting,
Is it that
most-
she was not able to quit, or was it that she needed to follow the included procedure,
Well,
the outline procedure
Your Honor,
as to how to opt out?
that's a great question. Because, yes, you can, again, the joke is, Hotel California, you can check out anytime you like, but you can never leave. She could quit the union anytime she wants, and she did. The question is, though, under that contract, the school district, her employer, kept taking the dues. And the union said, well, listen, yes, you can leave the union. And in fact, acknowledged that she had left the union. In the lower court, we have the response saying, sorry to see you go, we'd love to have you back. Our position is having a contract where both sides say you're out of it, but we're going to keep charging you for it. That's something that ought to be justiciable under the Declaratory Judgment Act, whether that's legit.
You're out of time, but I have one final question that I'd like for you to answer very
Yes, please.
very succinctly as possible. The issue of whether there's a contract to begin with, right? Is that independent to jurisdiction, or do we need to reach jurisdiction first before, regardless?
I think that would be, you would need to reach jurisdiction first, right? These are allegations
So
that
if we
she's
reach
made.
jurisdiction, we don't even have to address that, really?
Exactly, that's for the
All
trial
right.
court to address.
Thank you.
Thank you, Your Honor.
Good morning, how are you?
Was doing great till it started raining from the parking lot to the corner.
Yeah, really?
I'm
Well,
just glad it wasn't as bad as it
It's going to
could
be
have been.
today and tomorrow.
In addressing and responding to what appellant has claimed, first of all, SERB does have exclusive jurisdiction over any claim that is actually an unfair labor practice that has been filed with SERB, which is the case in the Littlejohn situation. She actually filed with SERB. SERB did review it, SERB investigated it, and SERB determined that there was no unfair labor practice that had occurred by the union when it decided that she had not followed the procedures or asked to withdraw within the window period. He is correct that because of a First Amendment's right to associate with whoever you want, they don't have to be a member, but they still have to honor their
So
contract.
my sense of what SERB found is
Or the card, rather.
that it's not so much that they determined whether there was or was not an unfair labor practice. They did not make that determination. They just determined that there was not probable, like, they made an initial determination that is not subject to appeal, and that's what kind of creates her catch-22 scenario. It's
don't-
not like a decision on, I mean, I don't know, maybe there's a distinction to be made there, but it seems like if you have a full hearing and it's appealable, then there's a litigated unfair labor practice. If you don't even get to litigate it and they make a determination that's not appealable, then it's not preclusive.
The SERB in their decision, and if you review it, that was attached to I believe the plaintiff's complaint, I think it was also attached to our motion to dismiss. They said within their determination that no unfair labor practice had occurred, that the union did not commit an unfair labor practice, and in fact, that Ms. Littlejohn actually failed to follow the procedure and withdraw her dues within the time period. At that point, when SERB dismisses a ULP for no probable cause, there is an action that they could have taken, and it's not filing under Chapter 119. 119 is there specifically for addressing actual adjudications when they have had, as Your Honor suggests, the opportunity to have notice to present their evidence and whatnot. And if then they lose at that hearing, then they may appeal through 119.
Right, because that would be a quasi-judicial proceeding.
Correct,
Yeah.
absolutely. And that's not what happened here. So 119 is not available to plaintiff to appeal the SERB decision. As Your Honor did say, though, however, mandamus was available and could potentially still be available if there isn't some laches argument that might be sitting out there, but
So their catch-22, from your perspective, is not a catch-22. They, in
I don't
fact,
see
are
one.
not stuck. They have mandamus as a recognized
yes,
method of relief.
correct.
But that recognized method of relief is not so much on the merits of the legal issue. It's like a whole different standard, right?
It directly orders, what you're looking at is to say whether or not SERB looked at all the evidence properly and made a proper decision within their standard to rule that there was no ULP, and a court can order SERB to proceed to a hearing, and
So the court would have authority over that
I don't believe so now.
under mandamus?
This
Trying to
court
wrap
did
my
not,
mind around that.
Because that issue is not before the court.
But theoretically, the Court of Common Pleas, this court and the Supreme Court have mandamus jurisdiction, correct?
If that issue is placed before the court, I believe so,
Right,
yes.
so they could have, they could have included a complaint for mandamus.
They could have, or just a complaint for mandamus, ordering SERB to review that, and then after, if they disagreed with what happened, they could have appealed through the court system, through 119.
So what do you say about the cases that say, it seems like there's this like, here's the test. The test is, did you file with SERB? And then SERB has exclusive jurisdiction, and then there's kind of this dangling, and of course, there might be some other independent bases for a independent claim. What do you say? Like, it seems like their whole argument is like, this is an independent contract claim based on the checkoff agreement.
You'd have to look at, starting with originally the Nadel decision by the Ohio Supreme Court, and then most recently the Lakewood decision. The court specifically said, if that you have filed with SERB, you have given jurisdiction to SERB to make a decision determining the charge that you have filed. Or if the conduct that you allege in your complaint is conduct that, if true, would have been an unfair labor practice under 411711, then SERB would have jurisdiction. So in this particular case, both things are true. They filed with SERB, and the conduct they allege is unfair labor practice conduct. In their complaint, they claim that the union is failing to represent the employees because we're not letting them out, according to them, properly. And they also are saying that they're not being permitted to choose under 411703 not to support or assist a union. That's a violation of 4117B1. Both of those are conduct alleging
But
unfair
those,
labor
it seems like
practices.
those are not actually in the, I mean, that might be in the background portion of the complaint, but in the counts, it's more like, hey, declare that this is a contract, declare.
I would agree, they're focusing on that contract to, in my opinion, misdirect the real issue, which is SERB has exclusive jurisdiction. They went to SERB, and they got their time before SERB.
Their time before SERB in that circumstance, describe what that is. That's not really, there's no presentation, there's no hearing, it's just like a paper presentation to SERB.
Yes, and a position statement. All evidence can be supplied to SERB, any evidence you have. They ask questions of material evidence that they want to review. They take affidavits from anybody who wants to have the affidavit. Those are party.
Then if they make a probable cause determination that's the opposite of what happened in this case, then they set it for a full hearing in front of the board?
Yes.
And that goes through this general.
They also have this inquiry thing that they've been doing recently, so I'm not sure whether they do the inquiry, but yes, in the past, they've gone full
Okay.
hearing before the board.
All right, thank you. It's just one of
So
those
you're-
administrative agencies that's cloaked in strangeness.
Well, a lot of administrative agencies have procedures where things are reviewed or not reviewed, and then you can determine whether or not 119 is the way to go or whether mandamus. SERB in particular, the mandamus is the only way to go if it hasn't had a hearing or adjudication on merits.
So, counsel, your position begins with the assertion that she chose to file with SERB,
Correct.
right? An argument that I heard this morning is, in essence, that she didn't choose to file with SERB, that she filed with SERB because she didn't have any other choice based on a pre-existing determination from the 10th Appellate District, okay? So my question is this. Was that asserted at the Court of Common Pleas?
Not in the decision. I wasn't technically, originally, for the Darling case, we were a party, but we had only one individual in that, and we were able to settle that matter with that person. So we are named in there. The case went on after us, and we are a named party in there. So I wasn't there for the oral argument, and I wasn't there for the briefing. But in reading the decision, no, they weren't ordered to go to SERB. They were told that the claims that were being raised were unfair labor practice claims, and that they had to be brought before CERB first. And Ms. Littlejohn, I'm assuming in abundance of caution, filed the unfair labor practice, which since we've had other courts who have, common pleas courts who have followed that as well. They haven't been before a court of appeals yet, but who have all said so far that the CERB does have exclusive jurisdiction on that.
This isn't directly related to the issues on appeal, but what's the point of having her jump through these hoops to cancel the dues? She's expressed that she no longer wants to be a member of the union and doesn't want to continue to pay dues. What purpose is served by having this window that she has to comply with?
She signed a dues authorization card that was clear onto its terms. The collective bargaining agreement also references the terms in terms of our policy and what her actual dues card says. We have to let folks out because of First Amendment considerations on terms of membership itself. But when you sign a dues authorization card, it indicates that you have a time period in which you can get rid of your dues or cease paying your dues. We have an annual policy that makes it once a year, regardless of what the card says. Some of the older cards that were signed would link it with like a 30 to 45-day period before the end of the CBA, the collective bargaining agreement. We instituted on our own an annual period. So each year, 10 to 25 days prior to when the person signed their card, they have the opportunity to withdraw their dues and cease that.
And what's the purpose of that exclusive time period?
For some continuity for us, and because that's the agreement they sign, we can't. It's not good for the union to be in a position to have folks being able to willy-nilly come in and out. So when we don't force people to sign, they do not have to become members. But when they voluntarily sign, they sign obligations, similar to the gym membership that appellant referred to. You sign, whether you use it or not is up to you.
But she
you're still
said,
paying under
she
the
said
contract.
stop. She said stop taking my dues. But she said that outside of this period.
She did, yeah, she did. And
So
the
you-
first time she did it, we sent her a letter saying, look, you're outside the window. Here's your card. This is a copy of your card. This is when you need to do your withdrawal if you want to do that. She didn't do it that year. She went, and then next year, I think it was in '22, she again went out. She was outside of the window. We again notified her saying, hey, look, you're missing the window. This is when your window is. We sent her another copy of the card. In 2023, she didn't ask to get out. And at the end, in December of '23, is when she filed her unfair labor practice.
So effectively, she's still paying her dues.
Actually not. When she filed the ULP, there were some settlement discussions, and part of that was, we weren't ultimately able to settle, but part of that was we stopped her dues.
Has the issue of whether or not the checkoff agreement and membership itself is a contract been litigated in any forum?
Not that I know of. It may have been maybe in the private sector, but I don't know in the public sector. And it's unique in the public sector because 4117.09 authorizes the parties to negotiate for dues deduction with the employer. So it's unique to us that we have under 4117 specific authorization to have this kind of a dues authorization card.
But the employee is not, well, I guess they're subject to the contract. They're not a party to the contract between the union and the employer.
They're a beneficiary of the contract, which would include the language that we said within the collective bargaining agreement, as well as the language that they would have signed within their dues authorization card.
What provision is that you say author?
411709. I don't remember the letter off the top of my head. I want to say C, but I might be wrong. And also because
And I
of
have,
that,
and I
it
have
brings
sort
it
of
up under
a
jurisdiction
weird
side.
question. Is the contract really the CBA? And then this is just an additional term to that contract?
That is one way of looking at it, because we do reference the card. We negotiate to be able to have the dues authorization card with the employer. That ends up in the collective bargaining agreement, usually under dues deduction or union security, something like that, and that's where it is in the contract that Ms. Littlejohn, her employment's under, and she's represented under.
Not that we're going to necessarily be deciding that, but, I mean, you know, when we talk about the contracts, when it comes to, you know, it's really the CBA. And I don't know what the provisions in the CBA are and if there's any reference to the details of the membership.
It says
you know,
that they
then-
need, yeah, it does, Your Honor. It says
Yeah.
that they have to withdraw pursuant to, I think, the dues authorization card or any other term that we, as a union, come up with. And the other term that we came up with was we allowed annual withdrawal.
And that makes total sense based on the way CBAs are written. Yeah.
Yes, Your Honor. I don't know if I'm out
You
of time
have
or not.
1 minute if you
1
wanna-
minute.
if
Just
you
to
wanna
wrap
use it.
this up, I believe that the, you know, the court does not have the subject matter jurisdiction, one, because the appeal is not proper before you. It's not, because there was no adjudication with SERB. And secondly, because SERB has exclusive jurisdiction. A ULP was filed, and even if a ULP hadn't been filed, the conduct that is alleged within the complaint, even though it's surrounded by all this other contract language, was actually that she was not allowed to leave the union.
All right, thank you. Good morning, again. So you still have the whole of the 3 minutes that you reserved?
Thank you, Your Honor. I will be brief. Opposing counsel mentioned the Lakewood case, and I think that's significant because I want to address something. The Lakewood case, going to your point earlier, Judge Nestor, in the Lakewood case, I'm reading from the syllabus, the Supreme Court enunciates the test that the test for jurisdiction is whether one of the parties filed charges with SERB alleging an unfair labor practice, or whether one of the parties filed a complaint before a common pleas court alleging conduct that constitutes an unfair labor practice. And again, I would submit that opposing counsel made reference to if you file with SERB, you've given jurisdiction to SERB. No one citizen can give jurisdiction to SERB. SERB is a legislatively created entity. It's a creature of statute and therefore has only the powers that the statute allows it. In this case, the statute said you have the power, SERB, to determine unfair labor practices. Again, to my example, if I get rear-ended leaving the courthouse and I file my complaint with SERB, SERB will rightfully say, what are you doing here? At which
Well,
point-
so in the Lakewood case, they didn't file with SERB first.
Correct.
So isn't that, I mean, it seems like you want to say Lakewood is good for you, but it also seems at the same time, if you look at the nature of the complaint and the fact that the checkoff agreement is something that's authorized by the CBA, it does seem to have the flavor of an unfair labor practice as opposed to simply a contract claim. It's not like, here's a contract between Miss Littlejohn and either the employer or the union. It's, here are these things and rights that I have pursuant to an agreement between an employer and a union, and I want to escape the burden of that. And there's this way that's authorized by statute that this whole agreement exists.
Your Honor, I would submit respectfully that the test isn't whether the right has to do with the CBA. The test is whether the right arises from 4117. And in this case, all the claims that she's raised are these contractual or quasi-contractual arguments that pre-existed and you know, if 4117 were repealed tomorrow, would still exist. So the idea that just because it relates to the CBA, I think the court in Lakewood and the prior Supreme Court decisions on the same thing say, listen, just because it relates to a CBA doesn't mean it's a 4117 claim. And in fact, Ms. Littlejohn's claims are further afield, further from the CBA than those that were brought in Lakewood. Lakewood dealt with a specific grievance procedure that is spelled out in the CBA.
So you're saying that 4117 does not govern the dispute in front of us?
That's correct, Your Honor. That's really the whole essence of this. We went to SERB originally because the 10th District, and that was, we sought jurisdiction with the Supreme Court. The Supreme Court declined jurisdiction. That was the only law that was out there.
So let's say that we were to determine that 4117 did govern this, okay?
Yes.
And that's the premise for my question.
Yes.
And my question is, it seems to me that it would have been required for you to assert the constitutionality of 4117 from a First Amendment perspective. as opposed to challenge whether this was a contract or not?
I think it's a good question, Your Honor, and quite honestly, it's one that I haven't considered. I think there is an argument to be made, not only on the first, well, to some extent, I think the First Amendment ship has sailed on that. I think Belgao has made those determinations, and the Littler case in the Sixth Circuit, while not specifically adopting Belgao, has sort of leaned in that direction. So I think absent something happening at the federal level, that First Amendment claim is gone.
And that's what makes it, I think, troubling to then, I think that seems to undermine your argument that this doesn't fall under 4117.
Your Honor, the argument doesn't fall under 4117 arises exactly from those Belgao cases. Because what Belgao said is, this is not a First Amendment case. This is a purely private contract issue. It's a case of private contract. And under our Constitution and the statutes that empower and create the common police courts, the place to handle contractual disputes is in the common police court. Whereas CERB, again, a specific administrative statutory carve-out, is limited to hearing these 4117
But
cases.
ultimately, your argument is that this provision of the contract with the opt-out period is invalid. And in order for that to be invalid, it seems that there has to be a challenge to 4117, because that is rooted in 4117.
Again, Your Honor, I'd respectfully disagree. 4117 says nothing about the contract between a union member and its union. 4117 deals with typically the actions of the employer vis-a-vis the CBA. It can also deal with actions of the union in forcing people in or out. But in this case, and more to the point, she did raise this as a 4117 claim, and CERB said, no, it's not, categorically.
What about the relief of mandamus? It seems like there is this recognized alternative when there's some failure at the administrative level that you can file for a writ of mandamus. In fact, you could file for a writ of mandamus in any of 3 jurisdictions to try to correct an abuse of discretion by CERB.
And Your Honor, again, this is the catch-22 that she finds herself in. I think we could likewise argue that the step that she took was say, listen, we agree with you, CERB. These are not unfair labor practices. These are contract issues. And the place to file contract cases is common police court. Rather than sort of beating her head against, please, we want to get into CERB when CERB doesn't want to have her, for claims that she thinks don't really belong before CERB, but she had no other choice. She chose the common police court option because that's where this case ought to be. It's contractual, it's quasi-contractual. It doesn't implicate any 4117 right.
And do you know if that checkoff agreement or the authorization has been, whether or not that's a contract has been litigated in any forum?
It has not, Your Honor. Again, this has been an attempt. I represented the plaintiffs in Darling, and I represent some of these other plaintiffs that opposing counsel mentioned. We've attempted to raise this in a number of forums, in common police courts, in CERB, in the Court of Appeals. And the problem that keeps happening is someone keeps saying, well, sorry, not here, you need to go elsewhere.
Thank you for your argument this morning. Thank you both for your
Thank you, Your
arguments
Honor.
this morning. We'll take the matter into submission, issue a timely decision, and wish you both a wonderful afternoon and great week. Good morning. No rush. No rush.
Good morning, Your
Good
Honors.
morning. So as you know, there was no brief filed, no opposition, no brief filed by Ms. Tribble. You're welcome to argue this morning. Obviously, we're not going to be reserving time. You're welcome to submit on the briefs. I give you the election on what it is that you choose to do.
Thank you so much, Your Honors. I am going to choose to argue today.
Okay.
I will be frank, this is my first Court of Appeals argument, and I'm really
No
excited
worries.
to do it.
We'll be gentle.
Thank you. So I will go forward and argue.
Okay, no worries.
I, of course, will not reserve time.
Okay.
May I please the court? This is the very rare appeal, as you can probably see, where there's only one party, but ultimately both parties want the exact same result in this case. Ms. Tribble is pro se, she didn't file a brief in the appeal, and she isn't here today. That very well might be because she wants the same thing the village is asking for, which is to have these cases remanded so that they can be heard by the municipal court and that both sides can have their day in court on these issues. Ms. Tribble originally was the party that requested transfer from the Village of Newtown Mayor's Court to the downtown municipal court in Hamilton County.
And there's no
She
doubt that that was properly requested.
asked- Exactly,
It was-
that's exactly
It was
right.
jurisdiction and authority for that, and she met the requirements for that to be
100%.
invoked. Yeah.
And the village shared that position when she made the request. When she made the request, the village agreed that it was appropriate to transfer downtown and immediately undertook the steps to facilitate that transfer downtown pursuant to the statutes. What the village did specifically was it had the magistrate who oversees these mayor court proceedings, it's the duly appointed magistrate pursuant to 1905.05, overseeing these cases, sign all of the transfer paperwork. All of that paperwork is in the record. It's actually at TD2 at page 2 of each of the 3 underlying cases. And I'm literally looking at the signatures in front of me right now. All of them were signed by the magistrate himself.
So your position is that the proper procedure was followed by the village?
Yes,
And that the
exactly.
magistrate had the authority to do what was done?
Precisely. The issue in this case arose, and this is why it's important to mayors' courts throughout Ohio, and why I wanted to make sure I took the time to argue today, and why the village is obviously taken up this appeal. It's because mayors' courts very frequently, in fact, more often than not, and specifically in Hamilton County, almost exclusively run by a trained magistrate who's frequently a lawyer who's overseeing these proceedings. It's very rarely run by the mayor himself, who often isn't necessarily a trained lawyer. Here, it was the magistrate.
And that's sort of an interesting point, isn't it? That we have these mayor's courts where the adjudicator isn't necessarily
Isn't
a
the
trained
mayor.
attorney. Well, isn't necessarily a trained attorney as far as the initial authority that's vested into that court, which is vested into the mayor.
That's absolutely correct. It's a unique little creature of statute. It's not technically a court of record. There are ways for basically villages and municipal corporations to sort of keep things at home and resolve things as quickly and easily for both sides as possible. But of course, preserving the right for the accused to transfer downtown if they want to and to have those
So
municipal.
she never had a hearing in Newtown in the mayor's court?
No, she did not.
And she probably is not here because she might think, oh, I have won, it is over.
To some degree, potentially. So it was dismissed for lack of jurisdiction. So there was no hearing on the merits ever. Actually, what happened was we showed up for trial. It was set for trial in municipal court. She showed up in mayor's court and in Newtown, requested to be transferred downtown. We set it for trial downtown, and the village was there, our prosecutor was there, our police officers were there, but the appellee did not come to court that day. And what happened was,
You know, the dismissal raises some really interesting questions because, you know, there was authority to hear the controversy, which was the charge, right? And at the end of the day, it wasn't heard at all.
exactly.
So it's very interesting that it's like, you know, and it wasn't that, it was that there was a faulty filing with the initial filing because that can divest the court of jurisdiction.
Precisely, and we've seen that in other cases.
Right,
in
right.
fact, on these
This is
cases.
no, you know, you've overcome the initial jurisdictional requirements, and so there's proper authority to hear the controversy, but then it never gets heard.
Precisely, exactly. And the reason the trial judge dismissed it was based on an erroneous reading of the Village of Evendale v. Stacia Lindsay case, which was a decision out of this First District Court of Appeals. I can understand completely how the misunderstanding arose and how it
But, you know, what's an
happened.
interesting thing is like, it seems that there might be an argument that the trial court did not have the authority to dismiss the action. Do you understand what I'm saying?
Absolutely.
So even if there was an erroneous reading, the act of the dismissal, what was the authority for the dismissal when the initial requirements of jurisdiction had already been overcome?
Had already,
Yeah.
the village certainly agrees with that reasoning. We absolutely.
I would have loved to see that argument.
Well,
Because
we
I do think,
appreciate-
yeah, because I do think, again, you're bringing up a really good point that it was never heard. And as you're making that argument, it made me think about this. So I'd even come to panel thinking of it from that perspective.
I think
As
the
to
court's
under
right.
what authority was this even dismissed to begin with?
Precisely. There was proper jurisdiction, which was afforded by statute. That was there throughout and it exists as we stand here today. The authority, I think, in the trial judge's mind was the Stacia Lindsay case, but in our view, that just isn't authority for this result.
And what's the difference? How is Lindsay different? Just so we know your whole argument.
Absolutely, and that's a really important question, so I'm glad you asked. I think this is a great opportunity to clarify Lindsay. Lindsay was not incorrectly decided. Lindsay is distinguishable, and it simply doesn't apply to or govern or control the facts here. In Lindsay, no one signed the transfer paperwork. No one, not the magistrate, not the mayor, not anyone else. The word
So it seems like you also ask us to take judicial notice of that kind of the underlying paperwork and proceedings in Evendale. Was that did they just not have do you have any idea from your perspective what happened there? They just transferred it and nobody signed?
I don't know. Yes, that was what happened. I don't know exactly why that kerfuffle happened, but that's precisely what happened. The transfer paperwork was just blank. No one signed it at all. Now, the actual decision out of the First District Court of Appeals doesn't say that, but it doesn't mention the word magistrate once. The word magistrate is not contained in the opinion. It simply did not address the issue here, which is, can a magistrate certification suffice in place of a mayor's certification? That's the issue here, and that case simply didn't address it because they didn't have a magistrate certification to worry about, and the opinion doesn't mention that at all.
In
And the-
Lindsay, it was dismissed and it wasn't remanded, it was just dismissed?
Dismissed for lack of jurisdiction, precisely that it had been improperly transferred to the municipal
So
court.
it seems to me that that dismissal then brings it back to where it was maybe previously, which brings it back to Newtown. Because I don't think you can dismiss, I don't know.
And there were some other issues.
There's
Well,
some interesting,
It definitely is, and I think I see exactly where the court
do you,
sort of.
do you get what I'm saying?
I
It's-
do.
yeah,
There were
it-
some other facts in Lindsay. It dealt with some other issues. This is a very straightforward, narrow appeal. Lindsay also dealt with some speedy trial and other issues that had been raised below by the trial judge.
That's why
and
it's
were
like,
up on
wait a
appeal.
second, like, under what authority is this dismissed and it just goes away, as opposed to it going back to Newtown?
Was there evidence in the record, counsel, that the magistrate who signed the transfer was duly appointed under 1905.05?
There aren't specific findings in the record that that was the case. I can represent to the court that that was true, but it wasn't raised by any party below. It wasn't raised by the court. It wasn't raised by Ms. Tribble. I don't think it was an issue that necessarily, to the extent it was an argument that could have been made, was preserved for appeal. So I don't think it's properly within the court's jurisdiction, but very fair question, and the village would represent that we wouldn't think that would be an accurate argument, even if it had been preserved.
What part of the revised code gives the magistrate the authority to act in lieu of the mayor?
So it is the interpretation pursuant to the mayor's court rules promulgated by the Ohio Supreme Court of the statute section 1905-032B1. That's the at-issue statute, and it says in relevant part, the mayor shall certify all papers filed in the case to the court to which the case is transferred. And that's what the trial judge was relying on here. It does say the word mayor, but mayor's court Education and Procedure Rule 2B, which is guidance that courts regularly look to, including this court in the Lindsay case, regularly look to analyze these statutes, specifically defines the word mayor to include a magistrate appointed pursuant to section 1905.05 of the revised code. And that's precisely what happened here. We had a magistrate who is appointed pursuant to this rule, who presided over the hearings and properly certified all of the paperwork. And we think those rules are absolutely persuasive guidance. Now, the Lindsay decision was interesting because it discussed the rules at length. It didn't mention Rule 2B once, which I think further shows that decision it didn't care about this distinction between mayor and magistrate. The facts in that case didn't present that issue.
Did the rule exist at the time in whenever that was, 2018? The education rules, the mayor's court education rules?
Yes, the rules themselves absolutely did exist. The Lindsay decision analyzed heavily Rule 12D specifically, which is just simply unrelated to the facts here. I don't know off of the top of my head whether 2B existed in current form as of the date of Lindsay, but this issue wasn't raised in the Lindsay
How,
decision.
how are those rules issued? It seems like they're not law. They are guidance from the Supreme Court.
Yes, that's the village's
And
position.
how does the Supreme Court formulate and then promulgate the rule?
I don't know all of the specifics stating here off the top of my head of how they go about that rulemaking procedure. I understand, but I'm not positive. I believe that it goes through a notice and comment procedure, just as any, rulemaking would. And I do know that they are promulgated by the Ohio Supreme Court, and they are regularly looked to as guidance, both in Lindsay, and then we have another case cited in our brief that I can pull if the court likes as well, where the Hamilton County Municipal Court also regularly applies these in cases that are transferred from Mayor's Court. So we believe that really decides the case. It's not necessarily like that rule is controlling on the court, but it is on point and certainly the most persuasive guidance telling us the exact answer to this question. But as the brief goes through, there's also some case law and just other statutes in the same statutory scheme that 100% confirm that this is the way the statute is meant to be read, that magistrates are allowed to certify this paperwork. And that's exactly what happened here. And to circle back in closing to your question about judicial notice, I think the court doesn't need to take judicial notice of anything to decide this case. This case is decided on the basis of the statute, Rule 2B, and then reading Lindsay and realizing it simply doesn't address the question that we are asking here. So it's not controlling and it's not dispositive. All of that leads us to the right answer in this case. But Lindsay doesn't need to be overruled. It should be preserved, and this is a great opportunity to clarify it, to clarify that its facts were actually different. And the judges are welcome to take judicial notice of these legislative facts, which are really a policy-making step in terms of ensuring consistency, stare decisis, and accurate judicial reasoning. So it's not facts applicable to the parties in this case. It's simply applicable to Lindsay. So unless the court has any...
Yeah, I do have one last question based on what you just argued of what it is that you're asking us to do. I want to go back to Lindsay, and you mentioned that there was speedy trial issues with that case. What was that adjudicated? Was there a determination on speedy trial?
So the speedy trial issue had been raised by the trial court and preserved and analyzed at the trial court level, and then that issue was up on appeal. The court actually ended up sort of being stopped almost by the issue of jurisdiction, whether it had properly been transferred and certified to the municipal court at all. It hadn't been in that case, so that was a threshold defect that deprived
What was the
court.
determination of the trial court on speedy trial?
At the trial court,
Yes, correct.
I am sorry, I don't recall exactly how Lindsay came out on the speedy trial at the trial court level. I believe, but I'm not 1,000% sure, but I'm mostly sure that they dismissed on speedy trial grounds, and that was really the basis of the appeal. The appellate court was more
Because that
interested.
brings me back to my question, and then you're asking us to clarify Lindsay, but it seems as if perhaps Lindsay is really dealing with the overall authority to dismiss the controversy completely, right? So in this case, we have two pieces. We have one piece, which is that whether the magistrate had the authority to do what it did, right? But the trial court made, in the way that that was handled, the trial court, in essence, made a determination that there was somehow authority to dismiss the dispute completely. You understand? So even
Yes.
though it didn't explicitly say that, in effect, on the action it did say that, because it took that action. So I don't, this idea of clarifying Lindsay, I don't know that it really addresses wholeheartedly what's going on here, but yet you haven't argued that part of the dismissal completely.
To make sure I understand, I think I understand what Your Honor's getting at,
Yeah.
which makes perfect sense. That we don't have, this was simply a dismissal solely for lack of jurisdiction. There was nothing substantive.
But there was a
determined.
determination of jurisdiction that went beyond whether there was jurisdiction to hear the case by the common pleas. There was also determination of jurisdiction on whether there was jurisdiction to hear the action at all.
I
Because what
see
the trial
exactly
court
the distinction
did,
you're making.
yes,
Whether-
I'm not making any decision, I'm just
Or
making an
distinction, I'm sorry,
observation.
distinction,
Okay.
not decision. No,
The
distinction
trial
you're
court,
making.
in its action, took two jurisdictional determinations.
Effectively,
Correct.
almost akin to a substantive and
Correct.
procedural bar.
And I think you would
concept.
agree that you've left the second part unaddressed in your brief.
I don't believe we have a substantive bar here at all to having the case remanded. I think the only bar that was ever found by the.
Oh, no, I don't, I'm not saying that. What I'm saying is that the way it's being treated right now is as if the only thing that, as if the case has been wholeheartedly dismissed.
And not sent back to mayor's court.
Right, that the trial, exactly, that the trial court said, I don't have jurisdiction of this because I'm reading that the magistrate didn't have authority to do what it did, so I'm not going to hear it. Mayor's court, it's yours again. And that's not what happened here. And that's not the way that it's being treated.
I think I see exactly what Your Honor's saying, so I
Yeah.
really appreciate that. We're in the same spot now. It's what could have happened here and perhaps would have happened here if the village hadn't appealed it instead and we weren't up here. It was remanded back to, it was dismissed from lack of jurisdiction from the municipal court, so it would have been sent back to the mayor's court.
But it wasn't, the judge didn't really say that. The judge just said dismissed with no directions to remand, I don't believe. It wasn't like, this is going back to Newtown so we can get a mayor's signature. It's like, this case is gone.
His order in each of the three cases, I believe, said transfer back to mayor's court, municipal court has no jurisdiction.
No, so it
So it
was
did,
effectively a
okay,
remand.
all
So I
right.
think his intent for his orders, although, to Your Honor's point, they're handwritten, and you know how some of those orders in these cases are. So it's handwritten notation, but the intent, I believe, was to transfer it back to the mayor's court, but dismiss the case from the municipal court
Okay.
for lack of jurisdiction. The village's position is that the defendant wanted to be in the municipal court. She absolutely had the right to be in the municipal
So
court.
it makes me wonder this, and maybe I'm overanalyzing this. Is this a final appealable order? Do we even have authority to address what you're asking us to address?
We believe that this is a final appealable order, and the briefing addresses that in a bit more detail, but I can also address at least the section that provides for this court's jurisdiction. Give me just one moment. So these were taken as of right under section 2945.67A, and the village's understanding is that that affords us the right to appeal any decision granting any motion to dismiss as a final appealable order.
But it's a motion to dismiss of the action as a whole, which now we're saying is not what in fact happened.
We
What-
see it as a dismissal from the municipal court. It would have been remanded back to the mayor's court.
Right, so the
agree.
action hasn't been dismissed. That's why now I'm wondering, and I haven't, whether we even have authority to hear what you're asking us to hear, because there's still a live controversy that was intended to go back to the mayor's court.
There's a controversy, but it has vastly different rights, substantive and procedural. There are so many rights attendant to being in the municipal court and being subject to that procedure. That's what the defendant wanted. That's what the defendant's statutorily entitled to do. We don't believe that a mayor's court proceeding is the equivalent of a municipal court proceeding. The village would have been totally happy to proceed either way, but we think the defendant has this right. We are here effectively to champion that right. The defendant
But like,
requested
it's not her right, well, like, she could go back and just ask for she could theoretically just say, oh, I need the mayor's signature if she really wanted to get into municipal court. I mean, she's just happy she's not in court, right?
I think she is probably the most happy she's not in court, but from a hypothetical perspective, she could certainly do exactly as you're saying and seek the mayor's signature. We don't think that's necessary, and we simply think that's the whole heart of this appeal. We think there's jurisdiction because there's a vast difference between those two forums. There's a right to be in the municipal court forum, both for her and for us at this point, after she's requested it. We think that's very different than going back to the mayor's court. And we believe that the dismissal of the municipal court action with all of those attendant procedures and rights, which the village will never get back and Ms. Tribble will never get back, is a final appealable order of a sua sponte motion to dismiss under 2945.67A. And we would respectfully ask that these cases be remanded and that Lindsay just be clarified so that the state of law in this district and in Ohio accords with the statute and with Mayor's Rule 2B, saying that magistrates that are duly appointed are entitled to certify this paperwork, and it creates no defect in jurisdiction. Unless the
Right.
court has other questions.
Thank you. Thank you
Thank
for
you
your
so
argument
much.
this morning. Congratulations on your first argument.
Thank you so much, Your
All righty.
Honors.
Thank you.
Have a great afternoon. And we'll take the matter under submission, issue a timely decision. Good morning.
Good morning.
How are you doing?
Good. Beating this year.
Did you have a good weekend, Attorney Thompson?
I did, Your Honor.
Very
Yourself?
good. I did. I really had a very enjoyable weekend. Thank you.
Good.
Enjoyed that weather.
Yeah. While it lasts.
Would you like to reserve time?
3 minutes.
All right, whenever you're ready.
May it please the court, counsel, this case is about whether a trial court can deny expungement based on a demand for restitution that was never ordered. The court stated in this case, well, before I get to that, the standard of review in this case is an abuse of discretion. And the court stated here that essentially in order to get the expungement granted, either produce why the state did what they did or come up with $6,000.
So you acknowledge that that was what was said by the court?
Yes.
Do one or do the other?
Yes.
Okay. How does that go towards your argument that it seems to be saying that the court gave only one option, which was to pay the $6,000 restitution?
Because I don't know the relevance or the possibility of producing, from Mr. Campbell's perspective, why the state did what it did.
I'm not following.
It's not in his knowledge what the state's motivations. I don't know how he can produce that.
Well, and the state's motivation would be the state's motivation to seek or not seek restitution? What is the state's motivation that you think the court was trying to get to?
My best guess would be the plea deal, but it's not clear.
So there was nothing from the prior proceeding that indicated restitution was part of the expectation?
The judgment entry specifically noted $2,000 was paid, and that's the only information I had for this, that we had.
But your client would be aware of the amount of money that was earned using this false ID.
And he did address that. I don't know that the court took it into account, but he did say the $2,000 was his portion of the work done under this man's identity. He related to the court that there were multiple people working under the same identity.
But he could refute that it was the $6,000 tax liability would not have equated with the amount of money that he earned under someone else's identification.
Correct. And I know the state will mention it because it's in their brief that he would be joint and severally liable, but that was not part of the judgment entry.
But when the court says, you tell us how, either there's no justification for the $6,000 or, what the explanation is, that is within your client's ability because he would know how much was earned under that false ID.
If that's what the court wanted to know, that is what he related to the court, yes, that this was his portion of the money.
The $2,000 was his portion?
I believe that's what he said to the court, yes.
Okay, I want to make sure I understand your argument, okay?
Okay.
Okay, so it's not that the trial court gave Mr. Campbell one option.
Okay, I'm
okay.
listening first.
I'm trying, because you started off saying it was one option, then you seem to acknowledge that there were two options. So I want to go to, was there one option or were there two options?
One option is our position.
Okay.
That the first either produce why the state did what they did was
And then there's an or.
a false equivalency, I guess.
Yeah,
an
or,
impossibility.
so, I mean, you read what the trial court said.
Yes.
And what was it that the trial court said exactly?
Either produce why the state did what they did or come up with $6,000.
Okay, so the or gives two options, does it not? Just a matter of Boolean logic,
Sure.
okay? So then I heard you say that the trial court didn't have the authority to make that request of one or the other.
Yes.
So that's, I want to just get to what your argument.
Okay.
Is it that there was one option? Because that takes this whole discussion in a distinct direction. Then there were two options. However, the trial court didn't have the authority to provide those two options. Those are completely different. So which one are we at? Because you've got 15 minutes, and I
Yeah.
need to understand how to utilize those
Our-
15 minutes.
Our position is that this is effectively one option, because the other, frankly, both are irrelevant in this case.
Couldn't, I mean, it wasn't like it was that long ago, right? They could have gone and said, what was the basis for, they could have found out from the prosecutor, what was the basis for allowing him to only pay $2,000?
I could address that, but not without going outside the record. I would just say it happened in that courtroom.
Okay. And then I want to, again, I'm trying to understand, okay? So we have a statute that governs the expungements, the 2953.32, and specifically the D1 section. So is it your position that none of the factors under 2953.32 D1 applies to this, I'm going to call it request, you can call it mandate,
Okay.
okay? We'll say request/mandate from the trial court? Because whether the trial court had the ability to make that mandate request, it's either rooted in the statute or it's not rooted in the statute. And if it's not rooted in the statute, right?
Yeah, it is, I'm trying to be an advocate, but also be as generous as I can, I guess,
all right.
in that.
You see, and I'm just trying to
This wasn't-
understand your position, because, I have to understand, what am I looking at? How should I consider this? The way I articulate it with my team is, what lens are we using, And I'm fuzzy on the lens I'm using, right?
I think there's a lot of fuzziness here in general
Okay.
in the way this happened.
Okay. So
But-
I'm going to put that aside,
Okay.
Attorney Thompson. I'm kind of reading between the lines, so I'm going to put that aside, okay?
Okay.
Okay. When this was with the trial court and the filing that was in opposition for the motion to expunge talked about rehabilitation. And would you agree that that was a basis that the state had raised on
Yes.
a concern, right?
Yes.
Okay. Did you find in the record whether the trial court addressed or didn't address rehabilitation? In other words, did the trial court make a determination on rehabilitation or leave that unaddressed?
In its decision, it did not rely on that. It did, however, say that the state's argument was worthy at one point.
Okay. So it sounds like you can see a path that the trial court would not have, did not at any point address the state's concern on rehabilitation.
It did not, or did?
Did not.
Yes.
Okay. So if you were correct on your initial argument that we have now put to the side, it seems that the right remedy would be to remand it because a basis that is rooted in the statute has been left unaddressed.
I think that that is an option, but ultimately an unfair one.
Okay.
In that it is essentially to go send it back to the court and have the court say it wasn't, he's not rehabilitated.
Well, we wouldn't be telling the trial court to
Oh,
do
I know
that.
you wouldn't say that, but that's effectively what would have to happen if if the trial court wanted to deny it.
But there is precedent from our court that we have done similar things, saying, look, you
Sure.
didn't address this, that's a statutory basis, that is a raised statutory basis, and we remanded it for that to be addressed.
Well, I think that Mr. Campbell did address everything that he's done, and we know that the state said he wasn't rehabilitated, pointing largely to his conviction in a different county.
But the state isn't necessarily right, it's for the trial court to determine.
But I think this court could review the facts before it and determine whether discretion was abused.
But that sounds like de novo if we're going to be making a determination on rehabilitation.
That's a tough question.
And Attorney Thompson, this is the challenge that I'm facing with this case, which is what are the lens that I'm looking at? Because it created all of these questions, you understand?
Yes.
Okay? So I don't need, I'm not trying to put you in the hot seat, okay? At
No,
all.
I
At all, all right?
appreciate it.
I'm just trying to, like, I'm trying to put on the right set of glasses and looking at this case and understanding, like, what do we have in front of us? What's the argument? What's the argument really asking us to do with this?
I think the baseline here is that the court, whatever findings it made, it relied on a factor it couldn't.
So what you're saying, it's not rooted in 2953.32 D1?
Yes.
Okay, but again, if that was correct, then we have to deal with what do we do about this rehabilitation argument that was raised in the memorandum in opposition. I looked at both transcripts, was raised in the first hearing when he was pro se, and then raised again in the hearing where the determination on the expungement was made as well.
I suppose that our alternate position then would be that if it is remanded, it be with an instruction not to consider any unordered restitution.
Well, if you were correct that it was an improper and not rooted in 2953.32 D1.
I would say that
Which I hope the state
under-
is going to address.
And I would say, we would argue that in any situation, the 6,000 is improper because it was never ordered.
Okay. To order the 6,000 would be improper, is what you're saying?
Correct.
Okay. I appreciate that statement. Okay. So let me see where we are in time.
I'll reserve the remainder.
Okay. I'll hold you 3 minutes.
All right, thank you.
All righty.
The Court of Appeals, Your Honor.
Good morning. How are you?
Morning.
Did you enjoy your weekend, Attorney Hill?
Did.
Yeah. Yeah.
Took a nice little trip down to Augusta, Judge.
Oh, my goodness. I've been outed. It was a beautiful day in Augusta.
It's a beautiful town for a beautiful day.
Yeah, and then I came home to a big old toot and got to see the Natchez go down the river as it arrived, probably around 10 p.m., and it decided to make its presence known to the whole of downtown. So that was kind of interesting.
Very cool.
Yeah, yeah. So it was funny to see that on the cusp of,
Yeah.
So, okay, anyway.
So anyway, back to the matter at hand.
Enough of Riverfest.
Yeah, right.
Yes, Riverfest is this
Right.
weekend for anyone listening to this argument.
Great, Judge. Our framing of this case is a little bit different than defendant's framing of the case here. This, from our perspective, is a pretty straightforward 2953-32D1 issue.
Okay.
Obviously, the state below raised a number of factors, some of which we would argue the court certainly addressed. The court did not really get into our relative balancing of states' interest argument that I made in my objection below. I would say, though, however, that the trial court clearly did consider the rehabilitation issue under 2953-32D1C. It effectively credited our argument when it called it a worthy argument. What I would say here, however, is that the trial court was more taken by the situation involving the unresolved IRS issue with Mr. Howe, which, from our perspective, falls under the 2953-32D1E reason for Vic's objection factor.
And just to be clear, whether it was determined or not only becomes of relevance, thank you, based on our determination on whether whether it's a mandate or a request, or, if it was options of 2 or whatever, whether that was in fact rooted in the statute.
Well, what I'm saying is
In other
that-
words, whether the court even had the ability to do that? Because this has all started with a victim's concern.
Correct.
And how is it that the statute speaks on victim's
Well, the
concerns?
statute says that the trial court can consider any reason for the victim's objection. In this case, it does kind of get to an issue of just manifest justice, I would say, right? You've got this victim, Mr. Howe, who was victimized by Mr. Campbell not once but twice, 2 times, to the tune of $8,000 in unresolved, monies. The trial court confronted defendant with 2 options, and I would clarify for the record that Mr. Campbell had 2 options below. It was either, 1, explain what's going on here. Why did you get this colossal break in light of the fact that you victimized this guy twice? Or, walk the walk, make this guy whole, which, probably statutorily the trial court does not have authority to do that. But certainly, as the moving party, Mr. Campbell has the obligation to prove that this application is something that the court can grant. And certainly the trial court can request additional clarification on the circumstances surrounding the plea, especially where, as here, you've got the state raising the argument that subsequent to all of this, not even a year later, not even 2 months before he files this application, not even 8 months before the hearing, you've got this additional charge up in Warren
And I
County.
just realized that I made a wrong statement of law. Because if there was a determination on rehabilitation and that there wasn't rehabilitation,
That's it. These
then
are
we're done.
conjunctive factors. Yeah,
Correct.
Yeah, right. The rehabilitation could just be the end of it right there.
Mm-hmm.
But here, we think the court has 2 options in front of it here. Either it can determine that the trial court properly found that Mr. Campbell hadn't been rehabilitated. Alternatively, we could make the determination that the 2953-32D1E does apply to its concerns relative to restitution. That was a factor that the trial court could certainly consider, basically that this gentleman over here is still dealing with this situation 2 years later. He's out $6,000 to the IRS. They're harassing him for money.
Isn't that though, that second part, kind of giving the state a second bite at the apple at restitution? It seems like it should be foreclosed.
I don't agree with that. I mean, there's 2 things going on here. Certainly, the trial court can't modify its previous restitution order, can't indefinitely hold Mr. Campbell's application hostage relative to that, however. But I think, given what the circumstances of this case are, that this is a very recent thing, that Mr. Campbell really could not provide any justification as to, or explanation, I guess I should say, relative to what happened here. He caught this considerable break. There is no substantive right to have a sealing or expungement. It is something where the trial court can certainly take a
What
victim's
kind of
concern.
explanation do you think the court expected?
I think it just wanted to know some more about the circumstances surrounding the plea, and I think it wanted some extraneous evidence of what
How long
happened.
before the expungement, I thought this was relatively close together.
What was that?
The conviction and this expungement, it's not like a
It was
whole.
about a year. I mean,
Yeah,
it
so
was-
it wouldn't be that hard to find out, right? Like why he got such a deal?
I think the fly in the ointment here, the problem is that there was this other situation with this double jeopardy argument. There was a case that got expunged. There was some question about whether this was an ongoing course of conduct. I'll tell you this, and I'm going outside the record here. Mr. Thompson alluded to this. I tried to beat the bushes. Gary Goldman, who represented Mr. Campbell, was my prior law partner. I tried to ask him about the circumstances of this. I pulled our file. I talked to the prosecutor. There was just really no good
So
explanation
it's
for
kind
why
of,
this
it kind of
happened.
is what it is.
Right.
And in a way, doesn't it seem unfair to like make somebody whole when the restitution wasn't ordered in the original conviction?
Well, it was an either or. It was either explain why this guy hasn't been made whole or make him whole. Mr. Campbell had 2 options. He was privy to those plea negotiations. He could have informed the court.
Was the transcript of that proceeding part of the
It was not.
motion?
It was not.
Okay. And did trial counsel request a continuance in order to order the transcript or do
not.
something to get the information?
No.
Does the victim have any duty to mitigate his damages? I'm just curious as to whether, submitting evidence that there's been identity theft would get the IRS off his back.
I can't speak to that again without going out the record. I spoke to Mr. Howell. I've read the case file. He was dealing with a tax attorney. I don't know why that situation's been dragging on for 2 years. He certainly made every effort to try and mitigate his damages here. But the fact of the matter
And it's
is,
possible that might have been part of the proceedings initially.
I'm sorry, could you
This-
clarify that?
The question by Judge Moore with regard to mitigation and with regard to whether in essence, whether the IRS would hold someone liable for somebody else's
And again, I'm going
action, that there's a possibility that that's why this $2,000 was determined to begin with.
I can't speak to that. All I can speak to is, and this is again going outside the record, those efforts I know from reading our notes in the case file. Those were ongoing at the time of the original proceedings. He was dealing with the tax attorney trying to resolve the situation. But the long and short of it is now 2 years down the line. I spoke to Mr. Howell, weeks before this hearing on this application, and that situation had not been resolved. And his position on this was, as long as I'm dealing with the IRS and the situation is unresolved, I don't think it's appropriate for this to be.
But he hasn't actually paid the IRS the $6,000.
They're still trying to get him to they're still trying to get $6,000 from him. I don't know.
That's what he's asserting,
Correct,
but we don't have any evidentiary matter on that either.
correct. So, this is the record we're confronted with, Your Honor.
Correct, yeah.
So, I would just reiterate, I think this is pretty straightforward, though. I think this begins and ends with the rehabilitation issue.
Mm-hmm.
The trial court basically credited that as a worthy argument. We raised it. It was
And in
properly
fact,
reserved.
at the trial court, did counsel for Mr. Campbell argue that there was no evidence to support what the victim was asserting on the lack of being?
I think he pretty much accepted it as true, Your Honor. That's my recollection of it. There was no real dispute that Mr. Howe was out an additional amount of money.
Okay.
And they didn't really rebut or try and
Understood.
challenge
Okay.
our contention or Mr. Howe's contention that had not been resolved. So, such is the record. If the court has any other questions, I'm happy to field them. Otherwise, I'll just submit on what I've written and what I've said today.
All right, thank you.
Thank you.
Thank you, Attorney Hill.
I think, well, before I get to that, I'll just say that even though I think it's entirely irrelevant, Mr. Campbell did address this deal on page 16 of the January 9th transcript. He said, "I remember going back to your office right here, me and the prosecutor and the detective, and we had worked up a case where I bring the seller in and the other persons that were working in the same name, Michael Howe. I got numerous IDs here and was also given to me from Mr. Gary that we had worked on the case." What he's saying is he presented to the state who the seller of this identity was. And that he goes on to say,
So you're saying that he in fact did address the trial court's concern?
yes,
But is that argued in your brief before us, that it was in fact addressed and that the trial court should not have made this? Because your brief is saying there was a mandate to pay the $6,000 and doesn't address the alternative, doesn't address or explain how we got here. And now you're arguing he did in fact explain, and I'm looking, thank you for giving me the page, I have it, I looked at it, I see exactly what you're referring to, okay? And it's an interesting argument that he did in fact address it, but have you raised that in your brief?
our position is it's just so irrelevant to the whole thing that it's all improper. That is our position, essentially, is that $6,000 that wasn't ordered, that he addressed, I only owed $2,000 because I brought you the guy who sold me the stuff. This was my portion, this is what we worked out. Doesn't matter. The question is, was he rehabilitated? And all of the other factors.
Right, so let's go to the rehabilitation. The state's position is that the rehabilitation, the opposition on rehabilitation was in fact addressed by the bench. And so that being, we're done, like, it's an affirm all day long, would be what they would be saying.
Well, it might be that way in terms of how it turns out, but the question is, was it an abuse of discretion? And the answer is yes. Mr. Campbell did his 2 anti-theft classes. He's got 2 jobs as a corrections officer and a car wash manager. 4 children, including a special needs daughter. He goes to therapy, counseling with his pastor. Nothing new since that conviction in Warren County, which was a misdemeanor. The state conceded he was eligible. So I would say that the court's position was focused entirely on irrelevant factors. It would have said you're not rehabilitated, easy peasy,
What was the misdemeanor conviction in Warren County
a
for?
theft.
So, a crime with a similar kind of animus
It's
that
in-
happened within a year?
I would argue, well, yes, it happened within a year.
So isn't that enough for the court to say you're not rehabilitated? You have a conviction that's essentially a theft conviction, and then you have another.
If the court had said that, we probably wouldn't be here.
Didn't the court credit the argument, though? They may have not been specific, but they credited the argument.
They mentioned it, but it's clearly not the reason this was denied. The statutes don't make Mr. Campbell ineligible because of that conviction. It's not an ongoing thing.
Are you saying that the court could not have denied it for two reasons?
No, I'm saying it could have, it just didn't.
Okay.
That conviction in Warren County is still there, as far as I know. It was at the time, so it's not a completely clean record. So to clarify, I'm asking that this court reverse and remand with instructions to grant the expungement because the trial court relied entirely on factors it could not consider. It did not consider restitution. The state wrote the entry that the judge signed, and it didn't mention rehabilitation. That's how this court speaks through its entries. Rehabilitation was not the reason. This was all about $6,000 that was never ordered. Thank you.
Thank you. Thank you very much for your argument this morning. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Enjoy all the precipitation we're going to be getting for the next 2 days. If you have lawns, the lawns will be a little happy. And wish you both a wonderful afternoon and a great week. Thank you.